Let me go over a couple of items of house cleaning. We're going to have a deferral on House Bill 34, which is a Superior Court Brunswick bill, and also the House Bill 155. This is a bill that we were working on. We've got some language in that I'm concerned about, that I was talking to DHR representatives, the criminal part of it, and we're going to hold that up. And Jill, you, I, and Adam, and maybe Betsy, who was a drafter of the bill, can sit down between now and Thursday and take some further study on that point and really clear up the language we want to talk about, is this defining of the criminal records in the bill as to the limitation of someone having the ability to hold these type of licenses. And clarify that. I want to be sure we got good language before we get before the committee with it. Let me call the first bill up, which would be House Bill 39. I believe we got Representative Chambers here, and so glad to have you with us.
Thank you, Mr. Chairman.
Do you have anyone else who's going to be with you, or?
No, sir, just me.
We're pleased to have you.
Thank you.
Tell us about your bill, House Bill 39.
Well, Mr. Chairman, esteemed members of the committee, thank you for having me here today. House Bill 39 is basically cleaning up some language on the exceptions to the Georgia Open Records Act. This language suggestion is based on an Attorney General's opinion that states this is the proper construction for this particular exception. This was brought to our attention after DeKalb County used this as the vague language that is there currently as a basis legal defense in an open records lawsuit. Superior Court in DeKalb did grant summary judgment for the citizens who requested information under the Freedom of Information Act, and on the basis of this construction. So this is just clarifying cleanup language. It is not to be considered a new law.
All right. Any questions of Representative Chambers? Yes, sir.
That's what brought it to our attention, Representative Fleming, although the cleanup language, of course, would be applicable in any situation. This clarifies that it must be an actual federal statute or regulation and not a federal bureaucrat mentioning, oh, by the way, this isn't subject. They must have it in writing through the federal government.
Because there were some requests, I believe, for some records at the airport that dealt with the size planes that went in and whatnot, and this code section was cited to prohibit it coming out. Is that right?
Yes, sir. Yes, sir, and the citizens were able to get the information that they needed. So, thanks to the Superior Court.
And there was a feeling on your behalf that this particular ordinance, this particular code section was being misused to protect some records that should have come out anyway.
Yes, sir.
Yeah, that's right.
Yes, sir.
Did we pass this as an amendment on the floor while that?
We passed it as an amendment on the floor in 2005. It passed out unanimously as its own piece of legislation in 2006, and we'll try it again this year.
Got hung up in the Senate.
Yes, sir.
I think what you had was you federally generated records in the possession of a state agency.
A county agency, actually,
well,
Mr. Chairman.
But a county agency. In this case, the open records that were sought, the request for those open records was being denied because they said, well, it's records generated by the federal government, not by us.
Well, the records are actually generated by the county, as far as I know, but they were using they falsely used the FAA as the whipping boy in this situation to say that the FAA would not allow those records to come forth when that was not true.
I have, Mr. Fleming, for your information, underneath that bill, there's an old bill, House Bill 684, that I asked to be put in the jackets, and you may recall this was something we've had debated several times dealing with the open records, and the issue about having need of something to be placed in writing as a part of the process of obtaining open records, so there is understanding specifically about what records someone is requesting. And you used the example several times from your county that you represented as a commissioner, where people come in and make requests for records. It's just verbally made. It is still a obligation to provide those records, but then a dispute may or may not arise in the future about did I get what I asked for type thing. Now, I bring this to the committee's attention. This has been something that we've reviewed on, I know, at least 2 occasions, 2 years, speaking of, and if anyone has an interest in looking at this as something to be a part of the bill, we can consider that. I don't know if Ms. Manheimer's here. Holly Manheimer represents the First Amendment. Anybody here with the First Amendment group?
I'm here with the ACLU, and Holly Manheimer could not be here
Okay.
today, but I can assure you that she would strongly oppose that.
All right. Well, I want to talk about it. That's why we keep having this issue come up. First of all, is there any other questions of Representative Chambers? Okay. Why don't you come around? Let me just ask you to introduce yourself, if you will, to the committee, and let's start a discussion. Yes, ma'am? Yes, ma'am.
It sounds like that you may be calling for somebody to offer an amendment to add 684 to her.
For consideration, right.
I would suggest, Mr. Chairman, that First Amendment Foundation, had they known that was on the agenda, certainly would have been here today. And
Well, they usually show up, I agree, and I was not pulling something, say, underhanded. I realized this morning this was one of the bills we put on there. It was something that has in the past been an issue. I wanted to raise that as a part of the committee's review of anything dealing with open records. Yes, sir.
Just for the knowledge of the committee, I was about to drop a bill dealing with that issue, so I don't know. It'd certainly be fine for me, whichever way that the chair would like to proceed.
All right. Let's first of all just talk about it. I just want to leave that as an approach to this point. Ms. Garrett, let me get you to introduce yourself.
I am Maggie Garrett. I'm with the ACLU of Georgia. Unfortunately, I am not quite as prepared as I should be to talk on this issue. I wasn't expecting it, and usually on open records issues, I do come with Holly Manheimer, who usually does the speaking on these issues. But I can just sort of point out the general objection we have to the writing requirement, and that is that the Open Records Act is supposed to be friendly for the public to get the records. By putting this writing requirement in there, it makes it more difficult for people to access the records, especially people who may not be able to write, may have problems with those forms. And so adding this one additional step, and I think that in many cases the public actually doesn't know as much about the Open Records Act as they could, and this just makes it one more hurdle for them to jump through to get the records.
I agree, and that's one of the things we try to address. What we did last year, when you look at the language here, this is on the second page of the House Bill 684. The language, I want to read this language out loud into the record so we know that we're talking about. It says, any other records or agents, where requests are required to be in writing, the party requesting the record shall be informed that the request shall be made in writing. The written request may be delivered to an agency by mail, facsimile, courier, email, or other delivery in person. The agency or public officer shall prepare and make available to the person requesting records forms upon which a person may make his or her written request, but the person shall not be required to use agencies or public officers' form. Then we added, the agency or public officer shall make a reasonable effort to assist a person making a request of records as needed. So we try to talk about that very thing so that they can't say, well, you got to give this writers. They can't write or they can't speak the language. There needs to be an effort made by the agency or the personnel to assist that individual to complete that request. Point being, we don't want to put hurdles up. I'm very much in favor of open records. I'm also in favor of clarity as much as possible. And the point being that we try to be sure that when that request is made, so that it does not later develop a dispute, that there's something that can be a written document. Well, this is what you asked for, and we responded by what you asked for, thinking we were completing it, type issue. Questions?
Mr. Chairman.
Yes.
Now, let me give you 2 examples of what this is trying to resolve, and you tell me there's a better way to do it. When I was chairman of the county commission before I came into the legislature, I walked in one day upon our county clerk, and she was fretting about something. I said, Phoebe, what's wrong? And she said, this fellow called in and he asked for this open records request, and I'm not sure I got it all down right. I said, well, I'll tell you what we need to do. We just need to get a form, and anybody who asks for something, when they come in, you haven't filled out the form, and there'll be no question that it's right. She said, I can't do that. I said, yes, you can. I said, and then I made that fatal error that I do try not to do that now that I'm a little older and wise. I said, I'm a lawyer. I understand this. I know that you can do that. That's ridiculous. Law wouldn't not allow someone to have to fill out a form. Of course, I was wrong, totally wrong, and she was totally right. And the reason she was fretting is that because there are penalties against these clerks if they don't give people what is asked for. There's another example of a municipality south of Atlanta where a gentleman who understands the law enjoys coming in, and I've heard this story on more than one occasion, and hollering either under his breath or out loud or whenever the clerks aren't listening well, hopefully, for his what he's trying to accomplish, that he wants this, this, and this, and he enjoys watching the clerk scramble to get a piece of paper and write it down because he's abusing the privilege that we try to afford our citizens. I mean, so those are the kind of instances that the chairman is trying to address here. And so what would your solution be to those two problems, if not something like this?
Well, I guess my first response would be, under the Open Records Act, you have to respond within 3 business days. However,
which this does not change.
Right. But I would imagine that in the person's response, as they're attempting to, with the first example, as they're attempting to respond, I think that would be counted as, yes, in 3 days you tried to respond. So I don't think that they would be penalized for not responding within 3 days if the person then added additional information. And again, I know that Ms. Mannheimer knows much better than I do how to redraft the law or how to deal with this issue in order to fix those concerns. Again, I sort of was a little surprised, but I can actually add one more thing. I know that in the past the Press Association, and I don't want to speak for them, but I know that they've also opposed it because of being, sort of in their trucks making phone calls to get records, and that would prevent them from doing that as well.
No, it doesn't prevent them from doing that. It just allows the local government to ask them to put it in writing if they so choose. It doesn't prevent them from making the request that way. You can still do it that way, and you can still respond. And I know reporters back home that I've discussed this with said that when we call, they give it to us no problem, and there's no reason that would be discontinued. It would, however, protect in certain situations of the abuses that I just mentioned.
It's my understanding that if the county chose to have the form, they could. Okay. I would imagine they would do it, require it by everyone, for everyone. Or both.
Any other questions of Ms. Gary?
Mr. Chair.
Yes, Mr. Jenkins.
I'm just looking at House Bill 684 juxtaposed against House Bill 39. House Bill 39 arose out of and was prompted by a lawsuit filed by citizens against the county. I mean, you would agree with me that the subject matter of such a lawsuit is the request itself, correct? I mean, why would we want any uncertainty as to what that request is when really, governmental entities could end up getting sued over such a request? I mean, you could end up spending a lot of time hashing over legal issue. Hashing over the content of the request when it seems very simple to make that a lot more certain just by simply requiring a writing, which could be handwritten.
Well, again, it comes to the point of it being difficult for some people to put it in writing, but also I would imagine that by the time it actually got to a lawsuit, there has been multiple correspondence back and forth over those particular details. So I don't think that it happens very often that someone makes an oral request for records and then they sue the next day. I think that's not very common.
But even if there's correspondence back and forth, the substance of the request could remain in dispute. I mean, you agree with me there, correct?
Right. In that situation, though, I would imagine that there would be some sort of an agreement upon what records they were seeking. So if they said, well, you weren't seeking these records, then you could file your request for other records and clarify that.
And who's going to arbitrate that? A judge. And so we have court time tied up with something that just required some common sense being applied to it, in my opinion. That's personal thoughts about it. I'm going to do this as far as the proposal on the amendment. I'm not going to accept the amendment. I want to encourage you, Representative, to go ahead and complete your bill, and I'll be glad to sign with it. I want the Press Association to have the opportunity, the First Amendment people to have the opportunity. I just want something done to try and clear up this nagging question we've had going on for the last several years on this area and how we can find a reasonable solution. Any other comments or questions? Yes, sir.
Got a quick question, and just for future reference as we talk about this bill, I would think, and I'd be sure to get your reaction on this, and I supported the Open Records package in 1999, and I'm glad that I did. I would think that a writing would actually be beneficial to both parties. And I thought about Mr. Fleming's example about the reporter. You know, when a reporter is trying to get some information, maybe out of a local government, or out of any government, you know, they call on the phone and I'd like to get this, this, and that. Well, what if that local government, for whatever, or any government for whatever reason, doesn't want to give over that information? And then, you know, the reporter shows up. Oh, I thought you meant something else. Then you get into this he said, she said, and all it really is a stalling tactic, and all of a sudden that open records information is not getting disseminated the way it should. I would think that by virtue of having the writing, it affords protection, and it lets that reporter who is seeking that information say, this is what I asked for, not that, here it is in writing, why aren't you giving it to me? And that sets up the closure of that matter as opposed to it potentially going on forever. I'm just sort of thinking out loud as I talk to you about it. What's your reaction to that?
No, I understand and agree with you in the sense that, you know, when I do an open records request, I usually do it in writing. You know, lawyers will most likely do it in writing. Newspaper reporters, when they have a certain amount of time or are looking for, you know, huge numbers of documents, they do it in writing because they are professionals in this field, know how to get the records, have, you know, lawyers to help them. And so part of our concern really is just about the average person who, you know, wants to just walk into the office and be able to say, these are the records that I need to get and want to get.
It's really what you're saying is the people who are unable to write, whether by physical condition or for some other reason, they're just unable to write. That's really what this is coming down to, correct?
Unable to craft the document so that it is, you know, perfectly written. You know, those are the concerns that I have, just for the average person who wants to get documents from their government, which those are the people that the Open Records Act are really supposed to serve.
Thank you, Mr. Chairman.
Thank you. Yes, ma'am. Ms. Thomas.
Okay. Well, I'd like to say hello to the members of the committee. All right. Also, what I'd like to say is I do understand what you're talking about, and I'm wondering whether or not when we craft a law, can you craft a law that says if there's a request by an individual who, because of physical ailment, whatever, maybe they're arthritis, or feels that they cannot understand this, that it is the duty of the person that is receiving that information to manually to write it for them, or some provision probably does have to be made, because what we do see as a citizen, a lot of times, anytime people see a form, even if they can read, write, and do arithmetic, as they say, they still have some level of intimidation because they're not used to the process. They feel that the process does not work for them. But as has been stated, I think that the Open Records Act was probably made for the regular person, because those with legal minds or well studied probably can negotiate through the system anyway. So if we did come up with some legislation like House Bill 684, it would have to be seen like some exception where those people who needed assistance would be afforded assistance and to get it written, and that the forms that we create would not be ones in which that we would consider, you know, so technical that a layperson would not be able to understand it. So that would be my concern, to make sure that we do accommodate that particular layperson's perspective in terms of accessing records. Thank you.
Anyone else wish to speak on the matter? Please, Ms. Oliver.
Make a motion for due pass of 39 at the proper time.
All right. We'll entertain that motion in a moment. We appreciate you coming before us, and we'll keep your eyes open. We'll probably have a bill come up sometime in the near future once Representative Hatfield gets his in place. Back on to the bill of Ms. Chambers, which is House Bill 39. Do we have any motions for that bill? We have a move to pass by Ms. Oliver.
Mr. Chairman. Second.
Yes, sir. Seconded. Any further discussion regarding House Bill 39? Ready to take a vote? All those in favor of the bill signify by saying aye.
Aye.
Opposed, like sign. Ayes have it. We have a due pass on the bill. Thank you, Ms. Chambers.
Thank you, Mr. Chairman.
We next have House Bill 53, which is the Piedmont Circuit by, we're going to have Tommy Bitten, and you're coming You are here.
I am here.
Okay.
All here.
I wasn't sure if you're going to be appearing. Yeah. On behalf of Mr. England, that's
Yeah.
right. Then tell us the purpose of the House Bill 53.
Okay. Thank you, Mr. Chairman. Allow me to come before the committee. House Bill 53 is a proposal to change the term of court for Banks, Barrow, and Jackson counties to create a uniform term for the Piedmont Circuit. Right now, the terms are staggered in Barrow, which has quarterly terms, and Banks and Jackson have semi-annual terms. This is part of tradition that was based upon the need for a single judge to preside over each opening of court. We don't have just a single judge anymore. There are two things that the bill will address besides changing the term, would be that after the demand for a speedy trial is made in a criminal case, the court must try the case within the preset term of the next succeeding term. This creates a different and more difficult timeline to meet in Barrow County, which has 4 terms, while Jackson County has only 2 terms, and Banks has only 2 terms. It leads to confusion in all 3 counties. It affects both the DA and the courts. The second thing is the fact that the court retains the jurisdiction to modify both a civil judgment and a criminal sentence until the end of the term in which the order was entered. This leads to a different deadline in Barrow from that in Jackson and Banks. The result of that is an extraordinary appeal which must be filed in Barrow. By having 2 six-month terms with coordinated dates, the courts, the bar, and the district attorney can easily establish deadlines. This bill will not stop the practice of seating 2 grand juries in each county of the circuit, and I ask for your favorable consideration on this.
Any questions of Mr. Benton? This does have the full endorsement of the entire bench.
Yes, sir, the 3 judges of the Piedmont Circuit.
And the thing I note, which is really the different thing, what we do in most multi-county circuits, we got all 3 courts terms beginning on the same day in each county.
Mm-hmm.
I don't know if I've ever seen that before.
Well, you have 3 judges.
I know.
So that was the reason. This was at the request of the judges to try to make it more streamlined and create some of the problems that were being caused by having different terms in the different counties.
I'll move to pass.
All right. You got any further discussion? I'll entertain a motion. We have a move to pass by Mr. Hatfield. Second it. Any further discussion? All in favor of the motion signify by saying aye.
Aye.
Opposed, like sign. We have a favorable.
Thank you, Mr. Chairman. Thank the committee.
I'm going to, at this time, get the individuals from the Department of Human Resources, because I think we're going to have some people who may also be here to speak on the bill. And this is on the House Bill 155, to come forward and talk about it and explain what we're trying to do at this juncture, and then we'll talk about the fact we're going to have come up front, please. Have a seat. Gina here? Did she leave?
Yes, sir, she did.
Okay.
We didn't realize
It's
that.
all right. We'll bring her up too. If you give us your name and with whom you're associated.
Good morning. My name is Sharon Doherty. I'm the Acting Director of the Office of Regulatory Services. And what I'd like to do is just talk briefly about the concept of House Bill 155. It's our hope that the legislature will consider is a change in policy to require owners of certain residentially based licensed facilities or private home care provider programs to not have a criminal record. Currently, the law does cover the directors and employees of personal care homes, child welfare agencies. There is no criminal record check required of private home care providers currently. What the bill is, its hope will do is prohibit an individual who acts as the governing body or the owner of the licensed entity from being able to have unlimited access to vulnerable people who are in care. And we feel that this is an additional protection that would be of benefit to our citizens. As you may or may not be aware, private home care providers, for instance, there are over 630 in our state. These are small businesses, and generally they operate, initially at least, some of those businesses out of the home of the license holder. Under current law, there is no requirement for a criminal record check on those individuals. This bill would cover those and require them to be licensed. Private home care providers go into the individual homes of vulnerable adults and children and deliver companion sitter services, personal care service, nursing services, and therefore we believe that they expose people, that it would be an opportunity for someone who has a significant criminal background to subject a vulnerable person to injury. And that's what we'll be proposing when we get the details worked out with the help of the chairman of the judiciary.
Any questions, first of all, from anyone about the purpose of the bill? Yes, sir.
We have a problem out there with people with criminal backgrounds running personal care homes. We think we have one.
There is a possibility of that happening in certain situations. They are the owner, but they do not serve as the director. If they're serving as a director currently, we do have fingerprint background checks in place, and we'd catch them. But if they are the owner and the license holder, there is no criminal record check required of that individual.
So we currently require a director of a personal care home.
Yes, sir, we do.
But not the owner of a personal care home.
That's correct.
Okay.
The one who actually holds that license.
And so as far as criminal background check, if this person had a DUI, I mean, what's the definition of what's going to keep them from doing it?
Good question. That's why we're holding the bill up. The language came in with the bill. I've talked to Ms. Travis about it. Ms. Travis didn't draft the bill. It was drafted by another member up there. But we had some concerns about if you look at the bill, first page, line 17, defining criminal record. We're looking to modify this language and put some better clarity about what are the standards, not a DUI, for instance.
No.
It's going to have to be a sexual predator type bill, either under Chapter 5 or Chapter 6 of Title 16, which are crimes against persons and sexual assault type crimes. And then we want to be sure that there is not the ability to have a first offender crime as an exclusion, that if they're going through a first offenders, that's still something to be considered on that point. So we want to reword the language on that part of it, and also we need to define better the community home.
Community living arrangements.
Community living arrangement, yeah, which is under another section of the bill.
Title 30. It would be under
3,
Title. Yes.
On line 22, we have facilities defined, and we put in there community living arrangements, also a type of facility that would be involved. So trying to do these changes right before committee, I said, no, we're not going to do it that way. Mr. Lindsay.
If I may ask, Mr. Chairman, when you're looking at those criminal activities that will be included under the bill, I ask that you also consider criminal activities such as fraud and dealing with monetary issues as well, particularly given the fact that we're dealing with the owner of the facility.
That's fine. We'll make it as broad as the committee likes. Yes, sir, Mr. Lay.
Mr. Chairman, how are the staff of these facilities treated in the background check process? Are they currently subject to background check in a way that if they're not expanded to them, because they could really be some primary instigators of abuse?
That varies by program. Generally, the staff of community living arrangements, personal care homes, and child welfare agencies, which are the child caring institutions, group homes, those kinds of things, all have a criminal record check imposed on them. Some do a state identification check. Others require fingerprints.
And I'll ask follow up to that. What is the penalty that may be imposed upon an owner who hires or retains somebody without going through those background checks?
Currently, when staff from the Office of Regulatory Services go out and identify a home that is in violation of the criminal record statute, they are cited for a rule violation. They are given an opportunity to correct, which would involve immediately removing the individual, and that citation is then tracked. And if we see a repeat problem, then they are fined as a licensed facility, and those fines can vary by program.
Okay, and how often are there examinations of these records, or the inspectors going out to the facilities?
That varies by program. In personal care homes and child caring institutions, generally we're out there at least once a year. We may also be out there on complaint investigations. There are some programs where we may not be out there every year. But if we do get a complaint where there's an allegation of abuse or inappropriate conduct, then that would be an opportunity for us to go in and immediately look at those records at that point and determine whether the owner or the director had taken the appropriate criminal record screening checks.
Anything further of the presenter? Yes.
Mr. Chairman, if I misunderstood your answer, I'm sorry for that. So is it, how many of the staff in a typical center of this type would be subject to an NCIC check?
Foster parents have a fingerprint check done, which would tap into that National Crime Information Center database. The frontline employees in I believe both in child welfare agencies and in personal care homes have a state check done, which is based on a name and identification. It is not based on a fingerprint.
And would that only pull the state or
Yes, sir, it would.
I don't know if it's possible for this bill. It may be another thing, but I know we've dealt with background check bills before, and I've always been surprised at how few are run through the national system, given how the transient populations are, how often across state lines. If you have a check that's only yielding a Georgia record, you're not getting as much information.
The follow-up, I'm not sure, but I know that in most cases, the GCIC is what you use, isn't it?
Yes, sir, it is.
They tie in and have national database as a part of access to it.
You're correct. In the instance where they have been convicted in another jurisdiction, it does come back as a multi-state, well, it used to be called multi-state offender status, that's noted on that local rap sheet. And then at that point, we require the individual to submit a fingerprint check at that point to determine what that crime is outside outside the state of Georgia.
But what used to have to be done is go through the GCIC, separately to the NCIC, but now GCIC ties in directly into the NCIC. Did you have a question for that? Yes, ma'am. Let's go.
Frank, you look my way.
Yeah.
All right. I just want to go, since it's on record. I just want to go on record to say that we really have some serious work to do in the state of Georgia as it relates to decreasing the inmate population in the state of Georgia, because what's happening is, specifically in minority communities, as well as Latino and African American community, they are misrepresented in terms of numbers in the criminal justice system, and then there's some issues around disparity in sentencing. But we do believe that people who commit crimes surely need to go to jail. But the problem what we're finding is that with so much with many of the jobs, like a job like this in a personal care home is what we call a low-paying job.
Yes, ma'am.
It's a low-paying job, just like nursing homes, low-paying jobs. And subsequently, all the people who are willing to take those jobs are those people who have a certain level of education and may have somewhere or another ended up in the criminal justice system. So we sort of in a situation where we want to make sure that in this industry that people are, the people who are getting the service are protected, but the people who more than likely would be taking this low-end job may also have been incarcerated for something, and maybe it could be recent, or it could be sometime in the past. So it's just, so I think what we have to do is, because we in a legislative perspective, we have to continue to protect the public, but then we also have some obligation to those people who have gone in, have served their time, and have made a new start, a second chance. Because otherwise, these are these low-paid jobs. Who want them?
There are provisions in the current statute for the employees, and I would agree with you that these employees need an opportunity. But there are opportunities to appeal that determination of an unsatisfactory record, and mitigating circumstances can be presented to the administrative law judge. So on occasion, then they are permitted to be employed, and the requirements that are applicable to employees or potential employees would be different from the ones that are applicable to the owner.
Last thought, what is the law now as it relates to nursing home persons who work in nursing homes? Do they also are subject to criminal background checks?
Yes, ma'am, they are. The nursing homes conduct those criminal record checks themselves, and they obtain that through the GCIC, and I believe that it is a local check, and they've got a list of crimes that are covered. And staff from my office also check the nursing homes to make sure that those criminal record checks have been done.
Employees as well, right? You said employees as well?
Yes, ma'am, it
Okay.
is employees and the administrators. Again, it's not the owners, though.
Okay, thank you.
Anything else, Ms. Dodd? Do we have anyone else today who would like to speak in regard to this particular bill? We want to give an opportunity for you to be heard since you're here. This is House Bill 155. No one else? As I mentioned, I'm going to exercise my prerogative. We're not calling up the bill at this time. It'll be put on the Thursday calendar for consideration at that time. We hope to have the language in a better state than it is at the moment. I mean, it's a bad state, just a little clarity about this issue on criminal records. There's someone, excuse me, come up for it if you'd like. I'm sorry, didn't see your hand up.
Actually, I just wanted to make a statement as far as I was a little appalled when she said that they only go out once a year. And I think that pretty much opens up the door for a lot of mishap. I mean, once a year, come on, I mean, you have agencies, you have beauty salon inspectors go to the salon more than once a year. So these are people's lives that we're talking about here, and for you guys to go out just once a year, I think it's not enough.
Hey, more of a appropriation and budget matter, but you're right. I agree with you. It probably is not a sufficient inspection. Proviso was it unless there's been a complaint filed. That's the other side of it. But she says that brings immediate response from their office if someone's filed a complaint about an individual who's under the care of one of these facilities. But I agree with you. We should have more staffing. Anyone else? What was your name? I'm sorry to get your name.
Tamika Williams.
Meekus Williams?
Yes.
Thank you, ma'am. Was there anyone else? Don't leave anyone out. All right, I'll exercise my prerogative. We'll hold this over till Thursday. I don't believe we have anything else at this time. Does anyone have any comments or things before the committee? We'll stand, hold on a second. This is no, that's been held over too, because I mentioned that earlier before you came in. We'll stand adjourned. Thank you.